Our guest today is Michael Breen from Reed College. The last time he was in this room was the summer of 2000 when Professor Holt and I organized a meeting of people to talk about how you turn your dissertation into a book. And it started with one of my students, Sarah Chapman, writing and saying, oh, I'm going to be in DC, can I talk with you about making my dissertation into a book? I said, sure. And then Megan Armstrong, whom you all met not that long ago, said, oh, can I come too? And then Sarah Beik said, oh, can I come too? And then Michael said, can I come too? And then Hillary Bernstein said, can I come too? And I said, only if Mac will say yes. And Mac said yes, and then we had a great Brown. And then Sarah Bean couldn't come because she was then pregnant and it wasn't going to work out for her at that particular moment. So we sat around this room, you may recall, Saturday and Sunday, talking about 6 dissertations, all of which were subsequently published. And that meeting also led to the creation of the University of Rochester series, whatever it's called, New Perspectives in Early Modern History, that Mac and I edit. And here's Michael's quote from that series: Law, City, and King, Legal Culture, Municipal Politics, and State Formation in Early Modern Dijon. It was published a while ago. Today he's going to talk to us about the legal world of early modern times, but more broadly conceived, not simply in France. So before you start, Michael, we'll go around, everybody introduces themselves.
Amy Leonard, Professor Faculty.
Jacob Byrne, third year PhD student.
Sometimes Cam, I'm a 8th year PhD student.
Jim Shadell here in the department. I do Central Europe.
Tommaso Serita, also here in the department.
That's early modern Italy.
Brenda Cameron Stanky, first year PhD student.
Matt Colletta, first year master's.
Susan Airmore, second year master's.
Natalie Donnell, first year PhD. Lee Stevens, second year PhD student.
Nathan Michaelwitz, 5th year PhD student at George Mason University.
Tom Adams retired from NEH back in 2008.
Max Woltz, retired from George Mason last year.
And I obviously am Jim Collins, and I'm not quite retired yet, but yeah, should be. All right. Now that I finally have a decent office, I can't retire.
That's right.
Mike,
okay.
please.
All right. So Jim has asked us to talk about our scholarly trajectory, in particular how we've moved from our first book to our current project. I'm currently working on this sort of broad synthetic history, the title of which is Law and Society in Late Medieval and Early Modern Europe. So I'm going to do this in 2 ways. One is to explain some of the questions about the history of pre-modern law, broadly conceived, that I developed in the process of researching and writing a focused local study on lawyers and municipal politics in old regime Dijon. And then second, I want to say something about this, I'm going to talk about this broader project in kind of general terms, and talk about how it's been shaped by my experiences teaching at a small liberal arts college. I think, I looked through the roster, I think I'm the only one this semester and maybe this year from such an institution. And the odds are that at least some of you may end up at a small liberal arts college like Reed, as the master's and PhD students. We have about 1,400 students, by the way. Our history department is actually decent size. It's about 10. But still, it's nothing like the department, say, here at Mason. So I wanted to at least touch on the kinds of opportunities such environments might open up for your scholarship, and also the ways in which they might influence. So my first book, published in Jim and Mac's series, was a local study of lawyers, or avocats, and their experiences as political actors in 17th and 18th century Dijon. I had been interested in the law and its uses as a historical topic ever since taking classes with Charles Gray and Julius Kirshner at the University of Chicago as an undergraduate. And I was particularly fascinated by the work of late medieval Italianists on the intersection of law and family through marriage and dowry practices. And I continued this at Brown as well with Anthony Mulho, who was on my dissertation committee. At the same time, I was also interested in the discourses and practices of absolute monarchy in old regime France, both as a result of studying with Keith Baker at Chicago and later reading Bill Beik's Absolutism in Society in a graduate seminar on the early modern state. Indeed, I should note that I first met Bill when he came to Brown to speak to our seminar, so there's a certain poignant symmetry in speaking today in this seminar named in his honor. Now, these interests were at the core of Law, City, and King, which was based in Dijon's rich archives and library collections, the range of sources preserved in Dijon, which I think Mac talked to you about last semester, city council records, tax registers, manuscripts, printed works, enabled me to study the activities and experiences of a group of prominent notables from a variety of perspectives, including social, political, intellectual, and cultural history. And through them I could trace how a key middling social group, which had long functioned as intermediaries between the royal state and local society, understood their place in the urban polity, as well as their city's place in the early modern French state. I was able to analyze how one socio-professional group, the advocates who pled before the city's courts, advised litigants, wrote legal commentaries, and even served as judges in seigneurial courts, used their mastery of legal concepts, languages, and procedures to navigate, negotiate, and resist larger processes of state formation. Now, several things stood out to me in the course of writing Law, City, and King. The first was just how thoroughly early modern French society was permeated by law. And by law, I mean a number of things. Various kinds of authoritative texts and norms, of course, such as royal edicts, provincial customs, and municipal ordinances, but also the universe of concepts, language, and principles through which these texts and norms were interpreted, contested, and deployed. I also mean the social and cultural contexts that mediated between law as a specialized discipline and those who used its resources. That means institutions such as law courts and legal professionals such as judges, advocates, procurators, and notaries. And it also means the panoply of procedures, symbols, rituals, and other cultural productions that conferred an aura of authority and even sacrality on the administration of justice. Another thing that stood out to me was the pluralistic and fragmented nature of early modern law. As Thomas Kuhn has noted, the discourse of the jus commune that provided the intellectual grounding of late medieval and early modern continental European law, quote, leaves one unable to, in many instances, to state flatly what the law was. Grounded in a panoply of rival tribunals, claiming authority from different sources and based on competing legal frameworks rooted in ecclesiastical, royal, Roman, customary, and other sources, law could be appropriated by different actors for divergent ends. Finally, I was interested in the ways laws served as a nexus between ideology and practice, a set of socially sanctioned institutions and practices for debating and then implementing different conceptions of the social good, as Amelia Kessler has put it. So this is where, in some ways, I think the influence of teaching at a liberal arts college comes in, because being the only specialist of continental European history prior to the 18th century, we have no medievalist, by the way, for instance. I'm responsible for covering most of pre-modern Europe, and so this sort of pushes me away from a France-centric focus, even though I do occasionally teach courses on old regime France. And also strictly from being an early modernist. I teach courses in the medieval and Renaissance Europe as well. My reading in the historiographies of other countries, including England, Spain, Italy, as well as the more recent colonial histories that are being done, really sort of brought home to me how, despite the sort of particularisms, France was not unusual in this period. Okay, what I was seeing in France was not unusual in this period. So I started teaching some courses. I had it really sort of grew out of a research seminar that I would teach for juniors to prepare them to do their senior theses. Students have to do a year-long senior thesis at Breen, so I taught this seminar, I still teach this seminar on law and society, which is really about how you use legal sources, as well as sort of different ways of sort of approaching the broad subjects of law and history as an avenue through studying things like social history, gender history, imperial history, so on and so forth. And it was sort of in the process of putting this course together and teaching it that it really occurred to me that while I was seeing very similar trends in these different historiographies, there was no sort of generalized attempt to approach the issue of law as a kind of social and cultural practice as a kind of more European-wide phenomenon. Really, everything was sort of siloed in their own respective sort of national historiographies. And so, to bring Bill back into this, I mentioned this to Bill Beik, who was editing this series of Cambridge, the New Approaches to Early Modern History series, and he said, "That's great, why don't you write a book about it?" And that's sort of how this process got underway. It was it's turned out to be a much longer, more complicated process than I thought when I proposed it to Bill. But anyway, Bill's spirit very much hovers over this book and informs this book, and it's I think a legacy of him in his career. So really, so to turn to this book, really at the core of it, there is a really fundamental question that interested me, and that is, how and why did law, again, sort of broadly conceived, become so fundamental to late medieval and early modern European society? What were the factors that enabled legal concepts and norms to emerge as a primary way of categorizing people, places, actions, and objects? And how did the framework provided by legal institutions, texts, rituals, and symbols come to rival and even supplant religion as the main social and cultural system through which Europeans comprehended their world and sought to act within it? How did lawyers, who appropriated the Roman jurist Ulpian's description of them as priests of the law, come in many ways to take on the roles of actual priests, trusted advisors, keepers of family secrets, defenders of the poor and powerless, oracles of truth, and intermediaries between the eternal values of justice and the prosaic, often sordid realities of daily life? There's more to this question, or to these questions, than there might seem. Law is so ubiquitous and integral to modern life that we can scarcely imagine living in a world without it, even though considerable sociological and anthropological research shows that formal legal systems staffed by experts trained in a specialized body of legal knowledge, what Pierre Bourdieu has called the juridical field, are not social, political, and economic necessities. The concept of legality, which is so fundamental to us, was unknown in Europe until at least the 12th or 13th centuries. Prior to this period, Manlio Bellomo argues, law was not looked to be an accepted, just, and rational way to prevent or resolve conflicts between individuals and order the life of the community, but rather as an accidental, occasional, episodic, but authoritative and written expression of the justice discerned in a particular instance, or a set of more or less independent rules applying to a variety of concrete situations. By the late medieval and early modern period, however, legal systems, in the sense of a consciously articulated and systematized structure of institutions clearly differentiated from other social institutions and cultivated by a core of persons specially trained for that task, were omnipresent, I think, across much of the European landscape. The number of specialized professionals who made their living managing, arguing, and judging legal disputes rose dramatically, as did the number and reach of official tribunals and the volume of litigation they handled. Castilian commentators lamented the disease of litigation sweeping their country, while Bernard de la Rocheflavin, a judge in the Parliament of Toulouse, wrote in the early 17th century that the French were, quote, so generally and for so long given over to the vice of litigation that it seems that there are no more than two estates in France today, one of those who plead and the other of pleaders. Law was so deeply embedded in European culture and society, in fact, that legal terms were among the first European words native communities in New Spain appropriated, and the ones that spread most rapidly and most widely. So how did this happen? For a long time, historians had turned to histories of state building and the so-called civilizing process to answer these questions. Official tribunals grounded in the combination of Roman and canon law, the jus commune, taught in university law faculties, or the common law tradition transmitted through the Inns of Court in England, offered they claimed, more rational and predictable justice than older practices such as oath-helping, judicial combat, and ordeals. They were also supposedly better suited to Western Europe's expanding, increasingly complex societies, where long-distance trade, new forms of credit, and more sophisticated property arrangements supplanted face-to-face social and economic relationships, making informal mechanisms of dispute resolution and social regulation increasingly inadequate. As kings and other rulers expanded the reach of their states and consolidated their control over the legitimate use of violence, vendetta and other traditional forms of redress became increasingly untenable, a process that dovetailed with the growing domination of the learned literate culture of Europe's elites over traditional oral culture of the popular classes. A recurrent theme of these histories is that official courts and those who staffed them were largely outsiders, imposing laws that were often intelligible and alien to ordinary men and women, who treated them with outright hostility and suspicion. One popular proverb, after all, advised that, quote, a bad agreement is better than a good lawsuit, while another warned, always mistrust justice. Complaints about the slow pace, high costs, and chicanery of official justice were also legion. Charles Loiseau famously evoked the plight of the poor peasant, who, to recover some goats and cows, is, quote, constrained to go before 5 or 6 justices before obtaining a final judgment. While the Spanish Enlightenment thinker Benito Geronimo Feijoo noted that in courts of law, the winner can end up the loser. Now there's sort of a question here, a paradox here, which is that if law courts and those who staffed them and the laws they applied were so alien and treacherous, why did so many people use them? It's sort of like Yogi Berra's famous aphorism, right? That nobody goes there anymore, it's too crowded. As it turns out, much of this earlier scholarship reflected a focus on criminal justice, which accounted for only about 10 to 15% of most tribunals' activity. It's really only in the past 20 years or so that historians have begun to look more carefully and systematically at civil litigation, which was the dominant activity of most courts. This coincided with the change in the way historians and other scholars studied how law and the courts worked, moving away from institutional histories of personnel and procedure in favor of what the German scholar Martin Dinges has termed the uses of justice, or, quote, the many ways individuals have dealt with the courts, which are understood as an institution of the authorities whose activities are only partially determined by those in charge, and were equally determined by the people who use them. If, as the French legal anthropologist Etienne Leroy reminds us, law is less about what texts say than what actors do with them, then what did late medieval and early modern Europeans do with the law? From this perspective, a very different picture of law as a social and cultural practice emerges. While power relations were certainly encoded in late medieval and early modern European law, it was in many ways less an instrument of elite domination than a forum for negotiating and contesting familial and social relationships such as marriage and inheritance, economic relationships such as property and debt, and cultural norms such as honor. It was, in Lauren Benton's words, a framework for conflict. Moreover, law, as I've mentioned, was pluralistic, fragmented, and contingent. Late medieval and early modern Europeans operated in a world of competing, overlapping, and imprecise jurisdictions, underwritten by differing religious and political authorities. As a result, those who used them had considerable initiative and agency in determining who would hear their disputes and which legal frameworks would apply. Litigants, lawyers, and magistrates maneuvered between multiple sources of legal authority, creatively and flexibly drawing on statutes, custom, Roman law, canon law, local usage, and other sources to resolve disputes in accord with equity and principles of distributive justice. The goal was less to ascertain which party was in the wrong or adjudicate whose rights were the strongest, but rather to restore peace and maintain social order. Early modern law, as Bianco Premo puts it, was more embedded in society and not a state institution. And since the law was only one means of obtaining justice in the justice-oriented legal culture of pre-modern Europe, it never monopolized or even dominated dispute resolution processes. So, law in late medieval, law in late medieval and early modern Europe then was quite weak. While it was increasingly professionalized and routinized, demarcated by a distinctive set of procedures, languages, symbols, rituals, and even spaces, overseen by specialized practitioners, it never became the autonomous sort of autopoietic sphere of knowledge and action described by the German sociologist Niklas Luhmann, or even the semi-autonomous social field described by anthropologists such as Sally Falk-Moore. Rather, it remained deeply embedded throughout the period in other social and cultural relationships. This weakness, I would argue, was paradoxically a source of strength, and an explanation for why the law in its various manifestations became such a ubiquitous feature of European society. Law's pluralistic, fragmented nature made it flexible and adaptable, facilitating ordinary Europeans' ability to appropriate it for their purposes. Similarly, the limited coercive power wielded by most legal tribunals made them appealing. Using the law was a choice, not an obligation. And finally, law was attractive precisely because it was not a system of rational, abstract rules applied by state institutions operating according to impersonal, bureaucratic rules and staffed by impartial judges who held office on the basis of their specialized training and expertise. Far from being obligated to transcend communal interests and entanglements and to administer the law in an unbiased manner without regard for the circumstances of a case, the individuals involved in it, or popular opinion, late medieval and early modern courts were, in fact, highly responsive to such circumstances and heavily reliant on communal cooperation and consent in order to function effectively. Pre-modern law was a justice, then, of men and women, much more, if not so, than a justice of laws. That this was so can be seen by looking at how judges and legal professionals who mediated between the world of the law and society as a whole conceived of their professions and how they were viewed by those who used their services. There was a great deal of anxiety about the way judges and notaries could abuse their arcane, specialized knowledge and grants of authority to take advantage of ordinary men and women and to corrupt justice. Thus, lawyers and judges' real authority came not from these sources, but their personal status and character traits. Judges portrayed themselves as wise magistrates who ensured the common good. Advocates were disinterested orators and servants of justice. Procurators and notaries were men of confidence who could be trusted to further their clients' interests not only in court, but in all facets of social, familial, and economic life. In the time that remains, I want to quickly discuss how and why people used the law in late medieval and early modern Europe, and how courts functioned less as sites of state's authority than as workshops of the law within broader societal structures and cultural norms. I also want to touch briefly on the ways legal professionals position themselves between ordinary men and women and the world of the law and society, not on the basis of their expertise or their mastery of legal procedures, but rather by highlighting personal characteristics that made them trustworthy mediators. Now, there were a great many reasons not to use the law in late medieval and early modern Europe. Christian preachers associated lawsuits with earthly discord and sin, and even in the best of circumstances, litigation was at odds with Christian virtues of charity and forgiveness. Going to court was viewed as an inimical gesture that threatened community and even family solidarity. The widespread use of insults such as possessif, caviloso, and barator to describe those who were too eager to sue provides a good indication of the anxieties linked with using the courts. Even efforts by rulers such as Charles V and Louis XIV to prevent the vice of litigation from infecting their American colonies proved futile, as colonial populations developed a reputation for litigiousness, prompting one dismayed French intendant to promise that he would, quote, devote myself this winter to rendering justice in this land and act so that the people will think of cultivating their lands instead of litigating. But late medieval and early modern Europeans were extremely litigious. By the end of the 13th century, to give one example, roughly 2,500 to 3,000 trials per year were taking place in the Italian city of Bologna. In England, more than 13,000 suits were in process at the Court of Common Pleas in the early 14th century, and if all English courts are taken into consideration, there appears to have been an annual average of about one lawsuit per household around 1600. Wait, it gets better. Some of the kingdom's more substantial towns averaged 2 lawsuits per household, meaning that there may have been, this is Craig Muldrew's estimate, more than 1,100,000 legal actions per year before English courts in the late 16th century. The 18,000 or so contemporaries of English men and women in the German city of Bremen, meanwhile, had roughly 2,100 civil disputes pending before the city's court in any one year in the late 16th and early 17th centuries. Now, there were, of course, Europe is a large, complicated place, variations across time and place, but litigation was, as Craig Muldrew has termed it, a socially deep process. Almost every man, and more women than expected, went to law in pre-18th century England, David Lemmings observes, and civil litigation was a common, almost universal experience in some areas, one that only the most destitute and marginalized did not participate in. Barriers to accessing formal justice appear to have been quite low. The clientele of Toledo's Fiel de Juzgado, a largely rural, mountainous jurisdiction, was dominated by peasant landholders, artisans, shopkeepers, merchants, and innkeepers. And a lawyer at the Chancelleria of Valladolid in the late 16th century reported that 9 out of 10 litigants who come to this world tribunal are tanners, dyers, innkeepers, and other tradesmen. Christopher Brooks's observation that the principal clients of England's central courts came not from the aristocracy or upper classes, but rather from the ranks of provincial farmers, merchants, tailors, miners, and even occasionally laborers, the so-called middling sort, can be extended to much of late medieval and early modern Europe. Women were also involved in litigation with surprising frequency. Nearly 1/4 of civil suits in the lower courts of late 17th and early 18th century Normandy involved women as plaintiffs or defendants. And Kuhn has shown how women were active in late medieval Florentine courts despite their supposed legal infirmities. It seems to be a recurrent theme that women, because of principles such as couverture or other legal disabilities, were not supposed to be active in courts, and yet we find them litigating in surprising numbers, usually on their own behalf. So even the poor were not absent from court dockets. At least 10% of the lawsuits before the Chancelleria of Granada in the 16th century were brought by impoverished inhabitants who qualified for free legal representation subsidized by the crown. People made regular use of the law because it provided them with resources for managing the vagaries of social and economic life, as well as the periodic crises most individuals and families encountered over the course of their lives. For most of the late medieval and early modern periods, law courts were Europe's most ubiquitous and highly developed governmental institutions. Early modern England, Muldrew notes, was a web of law courts, with literally thousands of jurisdictions where civil suits could be heard. Mid-17th century Toledo, a city of 25 to 30,000 people, housed at least 22 tribunals. And scholars estimate that there were as many as 20 to 30,000 royal and seigneurial courts in France, or roughly one judge for every 400 to 600 inhabitants. For most early modern men and women, litigation was the best way to invoke public authority. The law and its institutions thus provided ordinary men and women with a measure of agency, less by imposing specific rules on social and economic relationships than by filling in the gaps in individual and domestic relations. Courts were used to publicize grievances or acknowledge obligations, defend the reputations of one's self or one's family in difficult circumstances, such as the failure of a business or the pregnancy of a daughter or a servant, or to display one's respectability. They also gave official imprimatur to family decisions, named guardians and tutors for orphans, took measures to protect the interests of heirs by ensuring that estates were properly inventoried and transferred. Now, while Europeans used the law for many reasons, a few matters do stand out. Much of the growth of litigation in this period appears to be linked to the dramatic increase in the use of credit. In a recent study, Daniel Lord Smale has provocatively argued that debt procedures, far more than criminal justice, were responsible for the expansion of judicial systems in the later Middle Ages. And Brooks has noted that the enforcement of debts and obligations was probably the principal practical manifestation of the law in early modern society. 60% of claims before Leiden's Peacemakers Court in the mid-18th century were for debt, and early modern Bremen's municipal court, like so many others across Europe, was so inundated with debt cases that debt collection was its dominant occupation. Suits for defamation and insults also increased markedly, as individuals from a broad range of social backgrounds used them to defend their honor and reputation. Robert Shoemaker has charted the massive rise of slander litigation in English courts in the late 16th and 17th centuries. Men and women of middling status, wrote Christopher Brooks notes sardonically, sued each other for slander on a scale that we might associate primarily with politicians, pop stars, and other media celebrities. Commonplace books of Elizabethan and Stuart common lawyers were filled with long lists of words and phrases that would give rise to legal actions, as well as those that wouldn't. One book from the 1620s contained nearly 400 such entries. So a lot of things you had to be careful about what you said. Women in particular exploited the opportunities defamation suits provided to contest gender norms and negotiate the constraints of their positions as daughters, wives, and widows. The same was true, as we shall see, with women's suits for marital separations, whether of belongings or of goods and persons, as well as other kinds of suits, such as those to enforce promises of marriage or paternity suits. People also went to court, and I think this is important, because justice was, contrary to its reputation, and I think recent scholarship has really been showing this, generally quick, inexpensive, and satisfactory. Most litigation, it should be recalled, was handled by first instance tribunals that used simplified summary procedures, stressing oral rather than written testimony and limiting the need for lawyers. Leiden's Peacemaker Court disposed of many suits in 10 minutes or less. While local courts in northern Burgundy and La Valliere disposed of 80 to 90% of the suits that were brought before them in one or two audiences, a pace more or less matched by English summary courts. Initial costs of bringing a suit were quite low. Filing a plaint at a court of record in early modern England, for instance, might set one back 3 or 4 pence, while issuing a summons or having a debtor arrested could cost about a shilling, or the equivalent of a day's wages. Total costs were also modest. The Peacemaker Court was free, for instance, although occasionally one had to pay a little bit for random court costs, while fees for lawsuits in French first instance courts averaged somewhere between 5 and 8 livres. Even the cases that were longer, costlier, and more drawn out, the infamous lawsuits lasting decades and even generations, and there certainly were plenty of these, should not necessarily be seen as signs of dysfunction. Marie Ulimar has convincingly argued in her study of the Parliament of Paris in the 16th century that those who took their cases to the court weren't necessarily looking for the Parliament to resolve their conflict. Rather, they were looking for a forum in which to express their dispute. The lack of urgency in many of these suits in reaching a final verdict often had the function of encouraging opponents to reach some sort of mutually satisfactory or at least acceptable agreement. From first instance tribunals to high courts, lawsuits were less about having disputes adjudicated by neutral third parties than providing a framework that would allow litigants to air disputes without destabilizing the social order and creating a nonviolent and relatively dispassionate atmosphere for negotiating settlements that would ultimately prove more effective than final judgments. The interminableness and indecisiveness of legal proceedings helped keep lines of communication open even in the midst of disagreement, thereby avoiding the kind of rupture that a final court ruling would impose. Of course, this was not always the case. Indeed, Europeans learned early on that legal procedures could be exploited to humiliate adversaries and ruin them financially by making them, quote, eat their goods, as one saying went. La Rochefoucauld compared lawsuits to a type of war, and scholars have long noted how they mimicked many of the features and satisfied many of the same impulses as vendettas and feuds, albeit with lower risks of violence and bloodshed, but not zero risk. Gradually supplanting them, in fact, as these sort of socially acceptable means of remedying injuries, restoring honor, and afflicting one's enemies. Litigation may also have functioned as a form of conspicuous consumption, being used to display wealth and status by reminding others that one had the resources, the knowledge, and the will to defend their interests in court. It's important in all of this to emphasize that litigation was largely controlled by parties, and not the courts or officials, who depended on litigants choosing to bring their disputes before them for their status and livelihood. Ordinary men and women decided whether or not to bring their disputes into the legal realm, as well as when and where to do so. They also largely controlled the decision of when to abandon lawsuits and seek resolution by other means. Indeed, for the vast majority of those who went to court, the value of a lawsuit was not in its conclusion, but in its initiation. Only 16% of lawsuits in the 17th century English town of King's Lynn, for instance, proceeded beyond the initial complaint, and a mere 4% of the nearly 6,000 actions before the town's Guildhall Court in the late 17th century reached final judgment, a pattern that is hardly unusual for this period. People went to court to pressure another party to speed up negotiations, agree to mediation, or abandon a claim altogether. Going to court could also provide additional leverage or change the terms of a dispute and its eventual resolution. Far from working to delegitimize or undermine infrajudicial means of dispute resolution, law courts worked in tandem with them, offering the imprimatur of government authority to backstop private agreements and brokered settlements. Going to court, in other words, was but one gesture in a repertoire of scripts that often ended with an extrajudicial resolution of the matter at hand. We can see this by looking at recurring patterns, and there are definitely recurring patterns that show how official justice and infrajustice were intertwined. Debt litigation, as I mentioned earlier, was really the primary activity of many pre-modern courts, and really responsible for a lot of those sort of staggering numbers I mentioned earlier. Yet most cases were resolved almost as soon as they started. Sometimes debtors preferred to pay what they owed or simply did not contest their creditors' claims. And this is actually very interesting because they could have chosen sort of draw out the suit, contest the debt, sort of really sort of tie the process up as it were in court, but instead they don't. They just default. And so many of these debt cases that do reach final judgment are just default judgments, ultimately. So they don't contest their creditors' claims, making judicial seizures a quick and inexpensive way to terminate the claims against them. Many debt suits, however, really were actually served the function of recording debts that had been contracted orally and working out the terms of an eventual repayment, as these were not usually specified in the informal practices of borrowing and lending during this period. Credit in the early modern period really is more a social than an economic arrangement. It's a charitable and neighborly kind of arrangement, as well as a sort of practical business arrangement, right? Sort of shop credit, granting, sort of selling things on credit, letting people run on tabs in a tavern, things like that. But there's really no specified term of when the payment needs to be made or how much is to be made. So these are the things that actually get worked out, usually, on the side, and then sort of registered before the court. So the idea is that a debt suit often really is just a way of kind of formalizing these arrangements that have been worked out on the side. Slander suits followed a similar pattern. The church courts that heard defamation lawsuits in 16th and 17th century England, for instance, gave parties every possible chance to reach an amicable settlement before proceeding to judgment, and the vast majority of those who appeared before them availed themselves of the opportunity. To cite just one example, of the 27 suits for defamation in late 16th century York, only 5 went to a final judgment. Most were abandoned as friends and neighbors intervened to reconcile the parties and help repair any injuries to their honor and reputation. Scott Taylor has shown how Spanish communities expected people to withdraw complaints for insults in exchange for a public apology or other act affirming their honor. And these could take the forms of an apartamiento, which is a sort of formal withdrawal of a lawsuit and a kind of type of private pardon, or a fe de amistades, a pledge of reconciliation recorded by a scribe after a public reconciliation before a priest or another third party. Such reconciliations often required the posting of a bond or other form of surety with the court to prevent future conflict. Separation suits often prompted neighbors and judges to intervene in the hopes of rectifying the problem and reconciling the couple. A number of scholars have stressed that many lawsuits in this period were not really lawsuits in the way we understand them, but rather bids to broadcast one's rights to the community and to enforce them extrajudicially by encouraging communal intervention or the informal intervention of courts and judges. Law courts then were embedded in the societies and cultures where they operated, not because they imposed their authority, but because ordinary men and women invited them into their lives and used them as a space and framework for defining, contesting, negotiating, and ordering their social and familial relationships. Another way in which they were embedded in sort of early modern society was through the considerable influence that ordinary men and women exerted over them in their capacity as witnesses. Studies of lower level courts have shown how the testimony of villagers and members of the urban working classes shaped how laws, customs, and privileges were interpreted and enacted. In separation suits, for instance, witnesses articulated the community's expectations of husbands and wives and whether or not the couple in question conformed to them or could be expected to do so. Witnesses verified whether a debt or not a debt had been contracted and evaluated both the appropriateness of the creditor's request for repayment and the debtor's honesty and solvency. Similarly, courts relied on witnesses to ascertain what constituted an insult and how the matter in question should be resolved. Rather than attempt to impose externally constructed expectations on the cases before them, Julie Hardwick has argued in her study of Nantes and Lyon, judges gave considerable weight to community norms in applying the law and endorsed the standards that witnesses demonstrated were significant in their neighborhoods. So, that the actions of litigants and witnesses ensured that the workings of law courts and the application of law were embedded in communal values and reflected the broader concerns of interests of late medieval and early modern European societies was further enhanced by the fact that the judges who heard their disputes and evaluated their testimony conceived of themselves less as legal experts and agents of the rulers from whom they held their offices, and more as paternal figures whose wealth, status, and personal characteristics made them magistrates charged with ensuring peace and protecting the public good. Casey has shown that local Spanish judges were seen as little fathers of their communities, and that those who appeared before them made little distinction between their official powers and their sort of private status as sort of distinguished members of the community, and expected to draw on both of those sort of reservoirs of authority to resolve disputes. Similarly, Vincent Maisy has explained how presidial judges stressed their moral virtue over their technical competence. For pre-modern Europeans, going to a judge, for a judge to render an arbitrary judgment was not a system of injustice, but rather a desirable quality, because it was one that represented the fact that the judge was responsive to the desires of the conflicting parties and supported reconciliation between them. As one early 18th century English commentator put it, mediation and arbitration, whoever knows anything of the laws of the land and the proceedings of justices of the peace cannot be insensible that by far the greater part of those strifes and dissensions that come before them are such as are determinable no otherwise by them than as moderators and reconcilers of differences, and not as magistrates, in which they can act by any authority of law. A judicious and compassionate justice of the peace heals innumerable trifling discords and animosities, which, for want of such prudent interposition, might terminate in the utter ruin of the contenders. Another said that the magistrate was at his most useful, quote, when he acts as a peacemaker, when he removes secret animosities, puts an end to open quarrels, and prevents embryo lawsuits by private arbitration. Now, this amalgamation of professional expertise and personal character also defined the relationship between legal professionals and their clients during this period. I'm just going to say something very quickly about this to wrap up. Legal professionals certainly played an important role in facilitating Europeans' access to courts and their uses of the law to manage their lives. So understanding the basis of their relationship can be revealing. Notaries, as artisans of truth, produced documents and recorded them in their protocols. And these documents serve to provide their clients with a measure of protection in the case of future disputes and litigation, because the contracts or the testaments or the description of events that they recorded had the status of being legally true, so indisputably legally true in court. By formally representing parties and acting in their name, procurators made it more practical for men and women to use the courts, saving them the trouble of traveling or the need to disrupt their daily lives to attend to court business, as well as freeing litigants from the need to master the growing intricacies of legal procedures. Advocates were certainly the least commonly used, but they also served as advisors and counselors as well as informal arbiters. The legal professions, though, and this is not, I don't think, a surprise to any of us, this position helped generate profound anxiety. Notaries, there were rampant concerns about notaries as forgers and their ability, again, to sort of, not to manufacture truths, that is, to fabricate truths, and to abuse their positions. Procurators were often suspected of manipulating their knowledge of procedural complexities, again, to sort of drag out lawsuits and to kind of wring, as one pamphlet, to wring every last sou from the litigants' exhausted purse. It's a great early 17th century pamphlet, which is L'adieu du quai à son argent, right? Which is this history of all the ruses that procurators use to kind of bring every last penny out of their client. And advocates were, there was this fear of what was known as ambidexterity. There were advocates sort of serving both clients in a case, sort of betraying their client's trust, or similarly of using their legal and rhetorical skills to essentially subvert justice by making the weaker argument the stronger. And again, another sort of common lament in this period is sort of how many people have lost their lives and their fortune and their well-being to the clever words and skillful ruses of an advocate. The way in which this, just briefly though, certainly there were sort of ethical and professional standards that were implemented to respond to these, such as prohibitions against ambidexterity, as it was called, or particularly the regulation of how notarial documents were to be produced and preserved. That is, the form they took and the ways in which they had to be preserved in the protocol. And there couldn't be any blank pages in the protocol. Pages could not, you had to sort of start at the beginning and sort of record everything serially. You couldn't add or take anything out. But really, the way in which the legal professions responded to these concerns was more by emphasizing the personal characteristics and the special kind of traits, the special integrity of their practitioners. Notaries and procurators position themselves, and in many cases were actually as sort of trusted confidants, people that could be handled to sort of take care of their clients' affairs, not only in court, but in daily life, that is, brokering credit deals and property deals and things like that. Advocates presented themselves as Ciceronian orators and disinterested defenders of justice who labored for glory and not for money. They made a big deal of the fact that the money that they received from their clients were honoraria and not payment for their services, and that they were not actually allowed to sue for non-payment of services, although in fact they actually kind of were. But nonetheless, they made a sort of big deal about this. I mean, they're also lawyers, guys. Also always like get the money up front, make sure that you work the deal. But they make this sort of big presentation of, well, we do this kind of because we're devoted to justice and not for the money. So, as Marie Hulemer has pointed out, right, in fact, technical expertise, what we think of, especially for lawyers, as something that recommends them, that sort of validates them, is what made them suspicious to early modern contemporaries. And so that in fact it was not the technical expertise, but there's sort of this fact that they were hard workers, disinterested devotees of justice, citizens who were committed to the public good, that really in the end was used to sort of bridge this suspicion, or try to bridge this suspicion between legal professionals and their clients. So, where does this all sort of leave us? Just a few thoughts, because these are arguments that I'm still in the process of working out. So, one of the things that I'm most interested in, as I've said, is that is sort of how did the rule of law become so fundamental to early modern European, late medieval and early modern European culture and society? And what I'm inclined to argue is that, as an ideal, I don't think that this ideal of the rule of law explains why it became so fundamental to European culture and society, but rather the fact that the law had become so fundamental through these sort of contingent, gradual processes of appropriation, adaptation, and by being embedded in these more rooted social and cultural structures and personal interactions, is what sort of gave rise to this ideal, made this ideal of the rule of law a transcendent ideal. That is to say that the rule of law was the product of several factors: the pervasive, repetitive, and patterned contact between ordinary men and women and the courts of law that they used, and that this pattern helped encourage the diffusion of legal knowledge through written works, popular sayings, all sorts of other forms of knowledge, and what Anthony Musson has termed legal consciousness. And legal consciousness can be seen as both an active element in shaping people's values and beliefs and aspirations, as well as a passive agent in providing a reserve of knowledge, memory, and reflective thought. It's a complex phenomenon that enables people to reformulate their ideas and general opinions on the basis of their existing experiences and in accord with new legal opportunities. Law, he argues, is a material presence, a visual structure of everyday life, a heritable form of repetition which comes to constitute in a very real sense, a part of the nature of things. It is through symbols, its forms of appearance, its phenomenality, its emblematization of persons in public space that law makes itself felt. I think there are some other factors as well at work as well. The late 17th and early 18th century, at least in France, seems to be a period in which there's a profound kind of turnover, both among families of judges, but also legal dynasties of lawyers and elsewhere. There seems to be a sort of economic crisis and social crisis, and there's and a whole group of new men, as it were, who enter the legal professions. And it seems like that had a destabilizing effect, that sort of destabilized this kind of much more kind of personal, mediated, arbitrary sense of justice and the provision of justice that had prevailed in preceding centuries, and really made both judges, the new judges, and the people who appeared before them appeal much more strictly to the law as a kind of separate, neutral, defined set of standards and practices that had to be implemented, and not something to be sort of used and incorporated in a much more flexible and adaptive way. I think this can also be seen. It also happens sort of contemporaneously with the process that historians have described and traced of the sort of emergence of the idea of the rights-bearing individual in the late 17th and early 18th century. And in her book, Bianca Primo has argued that it's really in this period that we see a shift from what she calls a justice-centered legal culture to a law-centered legal culture. But she argues, in fact, that it's the litigants who go to court in the Spanish Empire. Women, slaves, in particular slaves who are suing for their freedom, and native communities who really appeal to this notion of law, so they're disinterested as being separate from the judges, who of course are connected to the elites who are ruling over them, who appeal to the king and to this notion of a kind of disinterested justice, disinterested law, I should say, autonomous law, to make their arguments. So ultimately, again, this leaves me with the conclusion that this idea of the rule of law sort of emanates out of the fact that law as a social and cultural practice had become so pervasive and all-encompassing, supplanting religion as a primary cultural framework. And it's not the explanation for why it became so. Thank you.
I have lots of questions, but you probably guess. But I am going to start with one because this is a history seminar, which is something that you touched upon, which I think is fascinating, and I'll mention one thing for those who don't particularly work on France. But I wanted to ask you about the connection between law and history in this period.
Yeah, right, okay.
Because those of us who work on France know in the 16th century of the rise of the so-called Mos Gallicus, which is about finding French historical roots for French law, rather than seeking them in Roman law using the glossators. And so, and many of the leading historians of that period are in fact lawyers, and there's this kind of reciprocal arrangement. Most of the people leading the royal government in the late 16th, early 17th century studied with Jacques Couillasse. So there's actually a very practical administrative aspect. So could you talk a little bit about the relationship of history and their renewal of the study of history and its relationship to law?
Yeah, that's a tough one. It's a good one. So I think, first thing is, we have to sort of, and this is something that I'm certainly aware with. I've sort of collapsed it for the purpose of this paper, but I do think that one can distinguish really, there are probably at least really two kind of legal systems at work in the early modern world. One is this sort of local system of summary justice, if you will, and then this sort of learned elite, sort of the world of the bailliage and parlementaires, and the jurists that we were talking about, who are arguing, developing these sort of new ideas in jurisprudence. And so in some ways, I think they're connected, but different. I think on the, so I'm going to try and come at this a couple of different ways. One is, I think, this sort of Mos Gallicus, Mos Italicus distinction that Jim is alluding to, that is this development of this idea that there is a kind of, first of all, that Roman law should be read kind of in historical context and not as a kind of, a set of principles and maxims that you sort of pull out and cite, you read carefully, kind of interpret, as the glossators do, right? Sort of like, well, what does this word mean? What does that word mean? What did Cursius say this word meant? And so commentating, glossing the glossators. But rather that it should be read as the expression of a culture, right? It should be read as historically contingent, and that therefore French, and therefore not directly applicable in the French context, because France has its own sort of culture and history. That said, Roman law was still understood to provide a way to help understand and interpret this sort of this French historical tradition. So it's not that Roman law goes away so much as how it is interpreted and used has changed. And so in that sense, I think it's actually a sort of good example of the fact that early modern European law, pre-modern European law is very sort of flexible, it's adaptable, it keeps being kind of sort of, it's open to continuous kind of reinterpretation and application. I don't know if this is answering your question.
It is. We can talk
Yeah,
more later.
sure.
Let's go to questions from
I guess
the.
yeah, okay. The second part, I mean, I guess just to sort of the second part, which we didn't get to, is, I mean, I think that historical, sort of awareness, there's awareness of precedent, of tradition. These are always arguments that are made as part of in the legal settings.
Questions?
Yeah.
Start in the back. Yes.
So you talked about lawyers self-representing themselves in a particular way,
Yes.
about they're there for the public good, not for the money.
Yes. Yeah.
I assume this is the 16th and 17th century, so I was wondering how different it is in the 18th and 19th century?
Well, I can say the 18th century is really where this idea becomes kind of the strongest, the most, where really, as lawyers, partly because lawyers really present themselves as kind of spokespersons for public opinion. This sort of the rise of this sort of idea of sort of a public sphere that is autonomous from the monarchy, for instance, and as defenders of public opinion. It's one reason why they're so they sort of position themselves. They're so prominent, I should say, in the run-up to the French Revolution and the early years of the French Revolution itself. So that idea, I mean, really, someone like D'Aguesseau, gives the speech in the late 17th century where he really sort of articulates these ideas. In the 19th century, I'm less familiar with that, but B, I think it changes. There's a good, and if you're interested, there's a good book by Hervé Louvers, a French historian who basically gives the history of the French bar from the late 17th century through about, I think, to about 1830 or so. And he traces that, and I think it becomes much more in the 19th century, if I'm remembering correctly. It's first of all, the profession is sort of abolished briefly during the Revolution. Right? So the idea that the bar is abolished because the idea is that you should be allowed to have anyone represent you, argue for you, speak for you before these courts, especially these new justice of the peace courts, which are meant to not be as sort of arcane and convoluted and complicated as the old regime courts were, that were supposed to be sort of honest and transparent and simple and staffed by lay judges. Eventually, the bar gets restored, and I think it becomes much more closer to more of a kind of profession in the modern sense, right? That again, it's sort of the technical expertise, the economic value. I mean, certainly, as you go on, there's also this French sociologist, Lucien Carpic, who's done a study of avocat, really from the early modern period through the 20th century. And really, his argument is that over time, certainly by the time you get to the 20th century, these ideals are still sort of there. The French bar appeals to them. They really do become more. It does start to resemble more and more the sort of Anglo-American conception of advocating for a client, and also again the sort of the economic benefits that their expertise can provide. So I don't know if that helps answer your question.
Yeah. I noticed you didn't mention the Enlightenment in your summation at the end, and it seems to me that that's particularly relevant for the 18th century.
Sure. Oh, yeah.
And the transformation. In fact, these new lawyers that you're talking about in France get accused of being the cause of the revolution.
Sure,
Burke
yeah.
loves to condemn them as advocates of Enlightenment ideas. But certainly in Central Europe, the idea of the rule of law, the Rechtsstaat,
Yeah.
changes materially.
Yeah.
And it becomes the royal road, both literally and figuratively, that it should come from above.
Right.
It should be the normal way of effecting positive change and turning the state into a eudaimonic institution that is there to improve everybody's life. And you
Yeah.
see this reflected in new law codes, both criminal
Yeah.
and civil, and that once you can put reform in the form of law, then it's permanent and it's assured to be a benefit for mankind. Plus, bureaucracy starts to displace courts, at least
Right,
at the
yeah.
lower level.
Yeah.
You should go to your friendly neighborhood bureaucrat, at least that's what Joseph II would like to see, and he'll resolve your problems. So it seems to me that that whole concept gets elevated to a much
Absolutely.
higher plane, and
Yeah.
that's part of what this transformation is.
Well, but I think that same value is, of course, what to go back to the French. I mean, the sort of the early revolutionaries, right? That is what they're trying to implement. Is again, is this sort of a constitutional monarchy, right? A polity that is governed not by privilege or by sort of particular corporate arrangements, but rather kind of universal law-driven polity. So yeah, I mean, I don't, I should look more at the Central European stuff, and I'm sort of, for the most part, have limited myself to Western Europe just for manageability sake. But certainly, from what I know, again, I think these I do think this sort of idea that the law itself is that this is something that this becomes a value in part because people are seeking it. Right? I think. I mean, again, this, and actually, it'd be interesting, and I think I'll have to go and sort of do a comparison. I mean, this idea is that I floated at the end. I'm drawing on a really good book by Bianca Prima, which is on sort of the Spanish and Spanish imperial world. And basically her argument is that the Enlightenment, she talks about the Enlightenment, means the Enlightenment on trial is the name of the book. And her argument is that it's the ordinary litigants who are coming to court who are making these kinds of arguments, not necessarily in a kind of derivative way, that is sort of giving an impetus. That at the same time that these arguments are going on among jurists, among philosophers, but that there's a sort of syncretism between the two. So without knowing more about the kind of practical workings of the courts of justice, in Central Europe, I'm loath to step too far in the limb, but I think my limited understanding is that certainly these same phenomena, at least in terms of the pervasiveness of litigation, the reliance on the courts. That said, as I think about it, of course, there was always this sort of tradition of kind of a top-down reformation. The imposition of Roman law, for instance, as imperial law in the 15th century. So there could be some different factors at work there. So that's something I'll have to give some more thought to.
You described or summarized how current legal historians no longer see the law or law courts as an arm of the state imposing order on an unruly people, but more as an arena where ordinary people can have their arguments heard, have grievances aired, not so much to achieve justice, but as a function to, anyway, you didn't mention criminal courts. how do criminal courts fit into that model?
Yeah, I think first I think to just say one thing about your question. I think they are seeking justice, right? They're seeking a different kind of justice in a kind of in a way that is not sort of legally defined, right? The law is one of many paths to justice. I think the basic answer is, by and large, there's not much of a difference, and one reason I didn't talk about criminal justice is, first of all, there's a tendency in the scholarship, and I think it's right to sort of downplay the distinction between the two, with some very limited exceptions, sort of capital murder cases and things like that. But that particularly for petty crime, what we might call sort of petty crimes, or sort of petty theft, that sort of thing. There really isn't much difference. Right? I mean, that is, the procedures are the same. There's not the use of the extraordinary procedure, judicial secrecy, torture, all of that, except when we get into these capital cases. And that, first of all, a vast majority of cases that do start out as potential criminal complaints are civilisés, they're called, right? They're converted to civil cases, basically private disputes, and resolved usually with some sort of fine, or if it's for assault or something, payment for the injuries, medical payment, medical bills, lost income, things like that. And the second is there's still, this goes back, going back to Cynthia Harrop's book on the common peace in England, but also more recent studies like Piant in France and others, is that there's the same reliance. The courts really do still rely on the community both to prosecute cases and to testify, right? And so that there's a real reluctance for people to prosecute their neighbors and their friends. And so that, of course, the full weight of criminal law really falls on outsiders and sort of recidivists, or people who commit sort of acts that are seen as sort of heinous, unredeemable, basically people who are deemed to be unredeemable, unreconcilable, but that otherwise, people, someone who steals bread to feed their children, for instance, if they're prosecuted, they're prosecuted really, people undervalue the value of the goods, so as to not trigger sort of felony statutes, or they drop the complaint when people don't testify against them. So that in the absence of and that there's really generally limited state, any kind of state interest. In the 18th century, it starts to change. Al Hampshire, his book on the possibility, talks about that. But even the procureur du roi, to take the French example, they have limited financial resources, so they're not. So unless there's a partie civile who's going to take the initiative and drive the case forward and conduct the investigation and gather the witnesses and keep the proceeding moving forward, they're not gonna, they might broker some sort of private resolution. Right? Again, they might act in a kind of unofficial capacity, or they might sort of send the parties to a third-party mediator or some sort of arbitration or something like that. So again, and again, but that's not to say the courts aren't involved, because they continue to be involved. So for instance, a good example is again sort of assault cases of violence and that sort of thing. Usually some sort of arrangement is worked out between the families of the people involved, and then that arrangement, and when that case shows up in court, it's to sort of register that arrangement. And of course the threat is if that arrangement is defaulted upon, then there might be prosecution. So that's really sort of how, it's much earlier. It's 13th, 14th, 15th centuries, but Dan Smale in his book on Marseille, I think, does a good job of tracing how these cases, even murder cases, get sort of transformed into debt cases, right? It's sort of privatized as debts between the family, debt of the family of the quote criminal and the victim, as well as the debt that the accused criminal owes for contumacy, right, for fleeing the jurisdiction, right? And then once the agreement is worked out, they're allowed to sort of come back into the city, be reintegrated into the city. Their goods have probably been seized by the court to pay the fine for contumacy and to pay the damages to the victim's family, but there's no the spectacular public punishment, the beheading, that only happens to people who don't have any other kind of family resources, financial resources, social resources to shield them from justice.
Nathan, and then Tommaso, are you about ready to ask your question?
Me?
Yeah, I saw your hand.
What?
So far, we've had a bad gender distribution of questions. I'm just pointing this out. Nathan?
Going back to the self-depiction of the judicial system is like their personal connection with the locality and their, articulation of reflecting the public good. You said this kind of really developed in the 16th, 17th century, and then was its most prominent in the 18th century. And it kind of made me think about its connection to, you said in the 17th, 18th century, that the growth of the new men in the profession destabilized the entire system. It makes me wonder, which was also connected to the justice-focused system moving toward a legal-focused system, if this self-depiction is kind of connected to the jurist doth protest too much, their own separation from the community, and so they're trying to reattach themselves in a rhetorical fashion that might not necessarily reflect reality as much as it did, say, in the 14th or 15th century.
Okay, so
kind of like they're trying to rhetorically reattach themselves to the community while they're kind of destabilizing it themselves.
I see.
If that makes sense. Maybe I'm drawing too much.
I think in fact it maybe goes the other way around, in that they are trying to distinguish themselves from the community and elevate themselves, right? Because they don't have the same kind of reservoir of family, family history or social status in the community. Tradition. They're not the son or the grandson or the great grandson of the previous judges, and so that they can't draw on that kind of authority. What they can draw on is their expertise as university law degree holders, and the fact that they hold this office, right, this position from the king or from whatever political authority. So that's where I think it's, and I think a similar thing happens with barristers and advocates as well. Right? They're not coming out of, there seems to be a demographic transition, but they're not coming out of the same established legal dynasties. And so they have to appeal to this sort of other source of authority. They also maybe see themselves as differently as for these reasons as their predecessors did.
There are complaints in they're interesting. Bourges petitions the king to close down a lot of the law schools, except for those courts, because there are too many lawyers already in 1576.
Oh, yeah.
Corbel de Croissy, in his report on Brittany in 1665, talks about how everyone is complaining that all of the children, the sons of merchants, want to be lawyers instead of merchants, and they ought to pass a law to prevent them. And of course, that's precisely the social group that's doing what you're talking about. Tommaso.
Yeah, thank you. So, just quickly on the criminal law, I mean, a long time ago I worked on that for Southern Italy, and what you say very much resonates with my sense of what I saw there. But I had a question about your response to Jim, because maybe I misunderstood you, but I thought you were arguing that there's actually a fairly big change in the 18th century, that in the earlier period, you have this picture of the whole judicial system as very much embedded in the society around it, whereas I would have expected you to, in response to Jim, to say that that's actually a major change, that now it's all kind of impersonal and abstract and coming from the top and all of that. But then you seem to, in response to Jim, to say that this is continuity. So I'm a little bit confused. Did I misread you in thinking that the Enlightenment kind of screwed up this lovely social utopia that
It's not a lovely situation.
No, I know, I'm joking, but I mean a situation in which things were more kind of organic in a way, and that the Enlightenment made it more formal.
I think the Enlightenment, I think it sort of changes the terms of the debate. I think it may be that there's this sort of correlation of the sort of demographic changes that are taking place, but also again these in terms of the Enlightenment, this emphasis on rationality, right? This emphasis on order and predictability, emphasis on an emphasis on universality, right? That rights, sort of rights are rights. And they're not sort of historically contingent or negotiated. They're not, and that they're individual, right? So that individuals have rights. They don't just have rights as members of a particular community, or on the basis of their social status. So I think you have a kind of. So I think you have a change. We also have the development of sort of natural law theory, right? The whole meaning, the whole concept of sort of natural law sort of changes too. I think in the 17th, 18th centuries, and so I think that it can become sort of unmoored from its religious foundations and rooted again in a sort of kind of universal rationality. I think that plays a factor too. I mean, that's certainly in these suits, these freedom suits, for instance, plays a role in that. Although what's very interesting, and again, I mean, I'll sort of go back to her book, because it's a book I really do recommend, Bianca Primo. And she talks about how custom, which is a very interesting argument about how native communities in the Spanish Empire use custom. They sort of appeal to that, but custom doesn't mean. But custom means something different. It doesn't mean this sort of timeless, kind of folk wisdom or the ways of their ancestors or something like that. Custom means like this is how things were done under the Habsburgs, and that and this is. And so that they should this is how they should be maintained. So custom there's actually custom becomes a kind of way of fixing very specific historical arrangements in time, and not this sort of transcendent these sort of transcendent notions. And there's sort of something they make sort of rationalistic utilitarian arguments in favor of custom, as opposed to this kind of historical, communal arguments. Particularist. They're not particularist. And again, I think another thing that does happen, I think is the Enlightenment really is where we do see the emergence of sort of ideas of legal positivism. I mean, really that take root in the 19th century, right? With the idea that law is supposed to be sort of unitary, it's supposed to be coherent, it's supposed to be hierarchical. Right? It's not pluralistic. It doesn't emanate from different sources that exist sort of in tension with each other, but kind of are different expressions maybe of this higher reality that is justice. So I think that, and it is a product as well of the sovereign will, right, and not an emanation of sort of a divine order. So I think there's that as well. So it kind of helps.
I want to, before we get to that, jump in on a little bit on the two ways. One is talking about this connection to the community. Most provinces in France redacted their customary law to be printed in the 1570s or early 1580s. And these tended to be reprinted in very elaborate editions between the 1630s and the 1660s. And every one that I've seen, and I've seen a significant number of them, begins with the procès-verbal of the meeting that had redacted the customary law with an actual list of every person who was present in the room. And in some of these bailiwicks, there are over 1,000 people on the list, right? So if you want to talk about, and we're not talking about big, huge provinces, we're talking about bailiwicks of which there are over 100. So we have quite a significant number of these where we have long, long lists of who was physically present to help redact the customary law of Amiens or Rouen or wherever the heck it might be. And I think that's exactly what you're talking about, that to show how deeply vested this was in the community. Amy, you have a question?
Yeah, I have a question about gender.
Sure.
And I'm curious
Good.
about the geographic differences and change over time. Because you said I think a quarter of the cases are women.
Well, it's one example.
One example, right.
Can I jump in here that that's based on a book written by one of my students?
Right.
Very excellent book.
Not surprising.
Excellent book.
I've seen many of these cases, but there is maybe change over time, and there's change in different places. I mean, like Germany, where I study. It's getting much harder for women to be able to go to the courts. They need guardians, and so it's actually becoming restricted, and obviously it gets restricted in other places. And Napoleonic code takes it all away.
Oh.
So I'm curious, do you see a connection between this change in the way justice is viewed from justice to law, a rationalization of it that writes women out? And so when when it's more of a societal thing, women can go can use the courts more, and as it becomes rationalized, women can't, because women are not rational. So it makes perfect sense now that if you're going to rationalize it, it needs to be masculine.
As long as you're asking that question, can you tie that into answering that question? Tie that into Sarah Hanley's whole idea of a family state?
Oh God! Thanks, Jim. Thanks a lot. I don't know if I can.
In 2 minutes.
And then everybody can
wine.
have some wine.
I have plenty of thoughts about the family-state compact, which is to say it's very problematic in a lot of ways, but does have, I think, some utility.
It applies best, doesn't it, to the legal elite, not to
it does.
everybody else.
Well,
That's the issue. That's to tie into your question.
Well, that's sort of what Robert Desimon and all of his sort of collaborators' work has shown. At least that's what I think it's shown.
Right, I agree.
It works as a kind of description of a social reality for a certain group, and not as an ideological construct. I don't know. I'm trying to think. I think that is certainly possible. I think that's a hypothesis I need to think about some more. I'm trying to think. I don't know. For France, at least, I'm not, in England, I'm not sure that there is that kind of trend, at least in the 18th century, but I haven't seen that argument made. I mean, I've seen it made in some respects, insofar as there's a sort of emphasis on a kind of strengthening a kind of patriarchal, hierarchical social order, really sort of asserting the authority of husbands, that the women might be sort of excluded. But the prohibitions are just as strong against women going. I mean, there are all these legal prohibitions against women going to court. Like, to take the case of late medieval Italy, right? There's the Mundualdus, right, in Tuscany, which is this sort of Lombard. Comes out of Lombard law, which is that a woman has to have a legal guardian, right? Someone, a male, who will represent.
But they still go.
But they still
right.
They work
this
around
is true.
it.
But it's
and
getting harder in Germany at least,
Yeah,
so they're starting to crack down.
and I think that I have to see. I mean, if that could be possible in some areas and not others. I mean, certainly separation suits in France, for instance, I think continue separation of. It becomes harder to win separation of persons for women, and there seem to be fewer of those suits, but they continue to be able to win separation of property pretty consistently. But again, that could sort of fit within a kind of, let's say, strengthened and revitalized patriarchal social order, in the sense that women become really the first creditors of their husbands. This is what sort of, this is a sort of legal change that happens in 16th, 17th century in Paris. So this transition from a kind of egalitarian community of goods to sort of male-centered lineage property. But wives, because of their dowries, become the first creditors of their husbands. So separation of goods becomes a way to sort of shelter and protect family assets. So that would be one reason why it would be easier to win, continue to win separation of goods cases, but harder to win separation of property cases. But at the same time, I mean, these sort of, we do have all of these costs. Many of these costs célèbres in the 18th century in France, at least, where do involve marriage cases, they do involve, sort of domestic tyrannies. Certainly, you do get these arguments, and maybe this is a counterpoint to this. Litigants, and the terms of litigation, and so litigants, but also their lawyers, of course, are presenting sort of marital suits in terms of arguing in terms of the husband's tyranny over the wife, and that this is a tyrannical arrangement. The authority of the husband over the wife is tyrannical and unreasonable, and therefore needs to be moderated, or the couple needs to be separated, or some other rights of the wife need to be protected. So this notion of a kind of husbandly tyranny or despotism, which definitely does pick up on the kind of political enlightenment rhetoric, again, with rights, I think does sort of speak to that. It does also speak to the kind of changes that are taking place in the conception of marriage as more of a companion relationship, as opposed to an economic, social relationship between two families. So but I have to look and see if that's a pattern. I'm not aware of it for England and France, but that's worth thinking about. We'll definitely look at that.
All right, we'll stop. Oh, Elizabeth, will give you the last question.
Yeah. I was wondering if I could ask you to say a little more about the relationship between law and economic life, because presumably a lot of the people going to court are in fact merchants, either individually or collectively.
Yes.
And I'm wondering if you're seeing any sort of changes in either commercial practice or ideologies over time that are instigating them to go to court more often.
Well, one is that I touched on is debt. And that, again, that's not my work, that's the work of a lot of other scholars. There's definitely a significant change in debt practices that takes place from the late Middle Ages into the early modern period. From where debt is really, debt and credit, I should say, credit would probably be better. Where credit really is primarily a kind of a social relationship, both hierarchical and horizontal. So it's either a way of kind of it's either a form of kind of charity, and almost sort of patronage or sociability. It's also a form of mutual aid, like sort of Christian sort of self. Christian aid, and if it's also a kind of just a pragmatic economic relationship. People, given the relative shortage of specie, right? to buy and sell often means people don't have ready cash, so they use credit. That does really start to change, and so people like Craig Muldrow have talked about this, Claire Creston, for an earlier period, Dan Smale. There's a name I'm forgetting in there somewhere. Julie Hardwick has also been studying it. Is that, but this debt is, the idea is that, in these sort of informal practices, the creditor is not really supposed to seek repayment. The idea is that the debtor will eventually sort of repay the debt, maybe over time, but that it's sort of unchristian or unneighborly to demand repayment. And it's actually in kind of an inimical gesture. It's a gesture of hostility. And it actually can redound against the creditor as much as the debtor, right? That you're not. It's kind of a withdrawal of charity and neighborliness. And debtors actually use this in their sort of in their protestations. That really does change in the 17th, beginning 16th, 17th centuries, maybe a little earlier in northern Italy, into more of an economic relationship. Obviously, it is different among sort of commercial, merchants, large-scale merchants, and whatnot, who early on develop sort of contractual and notarial forms for defining debt and credit relationships in terms of repayment. And that's one reason why notaries are so important to the whole process, and the contracts that they draw up and record. But it really does start to change, and one of the most significant ways is it changes both in England and in France it's the late 16th and early 17th century is the notion of bankruptcy develops, right? Criminal bankruptcy, right? That is, the distinction becomes made between faillite, to use the French term, which is essentially just inability to repay, and fraud. Bankruptcy is a form of fraud, right? That it's borrowing money that you never intend to repay. And people's behaviors do start to change as a result of this in terms of the kind of records that they keep and everything. Because they need to demonstrate that that if they're unable to repay a loan, that they're not frauds. Right. But this also is again where sort of community involvement becomes really important, because it's really sort of the testimony of neighbors and friends and associates that can play a large role in adjudicating these cases. People are very, very reluctant to accuse someone of bankruptcy, of being a bankrupt, as opposed to just someone who fell on hard times. So, yeah, there's, and the other book that I'm thinking of is which actually I think would speak to a question, is Amelia Kessler's book on the Merchants Court of Paris. There are significant changes that take place over time. But again, it's a kind of dialogic relationship. Behaviors change in dialogue with both the law and how the law is applied first.
All right, we'll stop there so nobody keels over from hunger or thirst.